Respected judges, we are just waiting one more minute for Advocate Vikram Singh sir to join, and then we will start the session. Good afternoon, Vikram Singh sir. All the judges are present here. Shashwat sir, you can start the session.
Very good afternoon to everyone present here. I am Shashwat Tripathi, Organizing Secretary of Second Justice Dipak Misra, National Moot Court Competition 2021-22. I welcome all of you to the final round of this event organized by the Advocates League. The final round is between JDMC 2229 as petitioners, as JDM and JDMC 2273 as respondents. To judge the final round, we have a bench of 5 distinguished judges. I would like to welcome all the distinguished judges. Today, we have amongst us Advocates Dinesh Dwivedi sir, Senior Advocate Supreme Court of India, Advocate Ajit Sharma sir, Advocate on Record Supreme Court of India, Advocate Vikram Singh sir, Senior Advocate Jabalpur High Court, Advocate Ajay Bhargava sir, Senior Partner Khaitan and Company, Advocate Neeraj Chaudhary sir, former Standing Counsel Union of India. I, on behalf of the Advocates League, would like to thank all the honorable judges for accepting our invitation and giving your time to judge the final round. I once again welcome all of you. I would now request Coastmasters to start the courtroom.
Thank you, sir. I hope I'm audible.
Yes.
So
yes.
there are certain guidelines before we. Thank you. So there are certain guidelines before starting the court. I request the participants from both the side to kindly switch on their cameras and kindly turn it on till the court is in session. Second, there would be 40 minutes time for each team to compete. An extra 5 minutes should be given for the rebuttal and the sur-rebuttal rounds. So with the permission of our honorable judges, shall we begin the session?
Yes, I think we can.
So the court is in session. Petitioner. Yeah, thank you. So petitioner, thank you.
Is someone noting the time division of the teams?
Yeah, the time division would be shown as well by sharing the screen from our side.
All right.
The counsel seeks permission to plead before this honorable court.
Just a second, ma'am. Just a second, ma'am. Court masters, kindly note down the time division between the speakers of petitioner and the respondents.
Yeah, so petitioner speaker 1 for it's total 40 minutes time that you get each team, and you can divide the times among 2 speakers, please.
Yes, sir. So speaker
Yes,
1 and speaker 2 both will be taking 20 minutes.
Petitioner.
So
Yes,
for the respondents,
Yeah, for the respondent side.
Respondents counsel 1 will take 22 minutes and counsel 2 will take 18 minutes. We reserve 5 minutes for the rebuttals.
Very good.
The counsel seeks permission to plead before this honorable court.
Please do.
May it please the court, the counsel would like to address the bench collectively as your lordship.
Yes, that works. Please proceed.
If your lordship is well versed with the facts of the case, the counsel would like to start with the issues.
Yes, can you give us just a very short, brief narrative of the facts of the case in a minute?
Yes, Your Lordship. Your Lordship, every year on 21st of November, the Jayon people celebrate their ancestral victory, and the same event was organized in 2017. Where just 30 minutes later, after the event started, was attacked by a group of people of Dungeon community, which led to widespread riots and deaths. This case was summoned to NIA for the investigation, under which the accused were arrested under UAPA Act for giving alleged hate speeches on the celebration day, which according to NIA was instrumental in causing violence. And they also arrest Mr. Duffy, the CEO of Twitter, based on superior responsibility for not removing the post, and Mr. Vishy, a journalist, for publishing the articles of the accused parties, which alleged to cause the violence in a village. The council is continuously saying the word alleged to make the court aware that all the NIA has merely relied on suspicion, and many bail applications were filed before NIA court and the High Court too for the bail, and all of them were rejected. And on 13th of November 2021, SLP was filed before the Honorable Supreme Court of India for the same, and many other organizations filed the petitions too, and the court clubbed all the petition under Section 139A of the Constitution of India. If your lordship is well versed with the facts, the council would like to deal with the issue.
Yes, please proceed.
Your lordship, I will be dealing with issue 1 and 3, and my co-counsel will be dealing with issue 2 and 4. The first issue before this honorable court is that whether the present petitions are maintainable or not. And the council humbly submits before this honorable court that petitions are not maintainable, as investigation by NIA is arbitrary and gruesome to such an extent that it is violating the fundamental rights of the appellants. The appellants have approached this honorable court under Section 136 of the Constitution, whose sine qua non was laid down by the court in Pritam Singh versus the state, and the sine qua nons were: first, the court should grant SLP if it is shown that exceptional and special circumstances exist and that substantial and in grave justice has been done. The second is the case in question presents features of sufficient gravity to warrant review of the decision appeal. And in this instant matter, both the conditions are fulfilled, because as the fact suggests, this celebration is going on for years and there is not even a single matter when there would be any sort of chaos because of it. The gathering was peaceful. Yes,
sorry to interrupt you, Counsel. So there are three matters now. One is the issue of bail applications by these 5 people who are in custody. I don't think we have any doubt, my brother judges would correct me, about the maintainability of those bail SLPs before us today. The issue is with respect to the other 2 writ petitions that are filed. Now, United Journalists has filed a writ petition before the Supreme Court of India directly, and an NGO named Equal Justice have also filed a writ petition challenging provisions of UAPA and demanding a transfer of investigation. So therefore, you have to address as to how these 2 petitions, I believe you are representing all of the petitioners before us today.
Yes,
so you have to address us. Yes, I'm sorry. You have to address us that in addition to bail applications, how are these 2 petitions maintainable, given that the principle of locus in a criminal proceeding is very restrained?
Yes, Your Lordship. Your Lordship, the other 2 petitions are under Article 32 of the Constitution of India, which can be invoked when the people are in that specific matter. The writ of habeas corpus is being used because the accused are unlawfully detained in this matter, and their fundamental right of freedom of speech and expression is being infringed. That is why the other 2 petitions are also maintainable.
Counsel, can a habeas corpus petition be maintainable if somebody is in lawful custody pursuant to a rejection of a bail order by court?
Your Lordship, but yes, Your Lordship, but in this instant matter, they are not in lawful custody. They are in unlawful custody because the charge sheet has not been yet filed since 5 years, and there is and the respondents are merely relying on the suspicions and allegations and no substantial proof.
So your only submission is that a habeas corpus is maintainable even against a person who is in custody pursuant to a court order. I don't think that's the law, Counsel.
Pardon, Your Lordship, the counsel couldn't get the question.
I think let me clarify. it's not a case of habeas corpus over here. What I find is that the bails have been rejected and therefore they've come to Supreme Court in SLP.
Yes, Your Lordship.
So if the bail has been rejected, you can come to Supreme Court because it's a tribunal. The trial court would be coming within the definition of the word tribunal, and SLP would be maintainable.
Yes, Your Lordship.
It's not a habeas corpus, please remember. If you've seen your notes, perhaps it's not habeas corpus.
Your Lordship, the council is justifying how the petitions that were filed by Equality Justice and United Journalist Organization is maintainable under 32. And the later on, the Supreme Court has clubbed all the petition with this petition of 136.
The only objection is 32 is not referred to in your note. It says 136.
Yes, Your Lordship.
So if the petitions are under 136, then they can't be under 32.
Your
And
Lordship,
even otherwise, is the bail cancellation order, bail application has been rejected. So therefore, it's a judicial order. There can't be an application of Article 32 to judicial orders.
Yes, Your Lordship.
Please go ahead. I just don't want to. Please go ahead.
Much obliged, Your Lordship. Your Lordship, in this instant matter, both the conditions, that is of substantial and grave injustice, are fulfilled, as the facts suggest that this celebration is going on for years, and the gathering was peaceful one until the people of the Dungeon community attacked the people of Jeon community with arms and attacked them. The violence resulted in death of 20 Jeon people, whereas 64 were merely injured. Upon hearing about this grave injustice that has been done against the people of Jeon community, NIA investigated the matter. However, the NIA arrested Mr. Perk, Ms. Tora, Ms. Brownie, Mr. Duffy, and Ms. Vishy under UFTA Act instead of arresting the people who brutally attacked and killed the 20 people. The NIA arrested the victim of the crime itself. Also, it's been 5 years and NIA has not yet filed any of the charge sheet because they do not have any substantial proof to back their allegations. They are, even after 5 years, they are merely relying on the prima facie evidences which they were having at the time of initial investigation. Your Lordship, the injustice is being done to such an extent that NIA has imposed UAPA on Ms. Vishy, who is by profession is a journalist in a local newspaper, for merely publishing interviews of people whose voice often remain unheard. Also, the council would like to bring into the notice of this court that these interviews were taken before the celebration. If this would have the potential to enrage the Dungeon community, then they would have gotten enraged long ago. They would have not waited for the celebration to take place. Also referring to Moot Para 11, Council would like to put forth this contention that NIA has alleged that interview could have enraged violence, but does not substantiate it with proof. For 5 years, NIA could not figure out the digest of the interview. The Council would like to bring into the notice of this Honorable Court that Ram Manohar Lohia case, in which the court held that state must establish a proximate or imminent connection between speech and violence. But NIA merely relies upon hypotheticals and remote possibilities. Your Lordship, punishing a journalist for assisting in dissemination of statements made by another person in an interview would seriously hamper the contribution of press to discussions of matter of public interest. However, the fact still remains the same that Ms. Vishy did not opine any personal view but published unharmful views of some people, and there is no visible nexus between the published interview and the violence that took place. Your Lordship, in this instant case, we can also observe the tyranny that has been imposed on these activists who merely were executing their right to peaceful assembly and speech of expression that is provided under Article 19 of the Constitution. The post was shared by Mr. Perk, had a clip of whatever brutality their community had faced at peace ground and made everyone aware of what they had to go through. And in 2015, the Apex Court struck down the Section 66 of IT Act in landmark case, calling it open-ended and unconstitutionally vague, and thus expanded the contours of free speech to internet. Because in that very case, the restrictions that has been imposed in that very section were very vague and wide, and one could not define these restrictions. In our instant matter, the reasonable restrictions that are mentioned in the subclause 2 of Article 19 are reasonable, but in this present case, they cannot be invoked because from the side of petitioner, the accused has never given those hate speeches. They are all just just made up videos, and they are not inflammatory in nature.
Counsel, the videos accompany a post on Twitter. The post,
Yes, Your
in your view, does it not amount to invocation and incitement? Because the post says that we should replicate what happened 100 years ago by Gaon people against Dungeon people in Mayanagri. What happened 100 years ago was an act of violence. I'm sure you will not dispute that. And when somebody who's a leader of a community puts up a post of people beating each other and says we must replicate what we did 100 years ago, does that not qualify as incitement and provocation, attracting UAPA provisions?
Much obliged, Your Lordship. Your Lordship, the Council would like to refer the case of Avik Sarkar in this instant matter, where it was held that whenever we are dealing with any sort of content and material, we need to look into the material with its whole entirety and not as isolated silos. If we look at the post of Mr. Perk, we could see whatever he has written and the video that has been attached to it. Your Lordship, this is subject to the interpretation of the people, and we need to interpret it with the mind of a prudent man, not of the person who would get incited by anything. The council at personal level would like to interpret it in a way that they mean to say that in a situation when so many tyranny was being imposed on their community by Dungeon community, where people has brutally killed 20 people, Mr. Perk was pleading them for being firm, for being confident, and not just get enraged and be firm, and just be courageous like their ancestors. Your Lordship, the Council would like to state an example that if even today, after the independence, we tell so many people to be very courageous and always respect our patriots like Bhagat Singh. But anyhow, it doesn't mean that we need to go to parliament and bomb the parliament like that. It is subject to interpretation.
I'm sorry, the analogy does not apply. If today you were to replicate the post of what Shahid Bhagat Singh did and replicate that and incite people to go into the parliament house and drop a bomb there, that's the analogy. Because your leader has said we should replicate what happened 100 years ago. Right? So encouraging is different, but incitement and driving people to replicate what violence happened 100 years ago is at a different level.
Much obliged, Your Lordship, but as his counsel has previously stated, that is subject to the interpretation from the mind of any prudent man, and not from the weak-minded person. If the council would also like to refer the case of Kedarnath versus state of Bihar, in which it was held that for any speech to actually be inciting and to be seditionary, the action must also be backed with the speech. In this instant matter, even if would have been inflammatory, it is not backed by any conduct.
So now you're saying the speech can be inflammatory, but then the court will have to examine, that's a matter of trial, the court will have to examine whether the video that accompanies the post is the action inciting people. You see, when Kedarnath was decided, there were no videos being uploaded on internet. There was no internet then. Unlike today, when you can write a few words on Twitter and incite lakhs of your followers and follow it up with a video post of people beating each other. So that's a matter of trial. Why should we interfere now and bail? We'll tell the trial court to expedite your trial.
Counsel, there is another thing which I would like to point out. Please don't take it in any other manner, excepting this. We are not charging. I mean, the accused have not been charged for sedition. Please see what the charge is. They have been charged under UAPA, which is not sedition charge. So this connectivity or disconnect between the speech and the violence that you are advocating hardly applies. Please have section 15 of the UAPA. It says terrorist act. When you are threatening violence, you are threatening a section of the population. It's a terrorist act. So,
Your Lordship,
I doubt, I would certainly doubt you going into the sedition aspect because that's not involved here. It's UAPA. Charge is UAPA. And it has to be under one of the provisions of UAPA, which is in all probability looking into the charge, it is section 15. So that is why you have to look into it. And plus, remember, this is a bail stage. This is a stage where you have been charged and you are applying for bail. There is no issue of discussion on elaborate discussion of facts or finding of fact, whether it is correct or wrong or it's incorrect. So the question is, you are at a stage of grant of bail.
Your Lordship, the Council would like to state that the accused are also charged under the Section 124A of IPC, which deals with the sedition.
How do you get out of UAPA?
Your Lordship, my co-counsel will be dealing with those charges, but they were also booked under 124 for seditionary speeches which they have given. As per the NIA, these speeches were seditionary. That's why they were charged under 124.
This is a bail stage. You don't have to prove anything at this stage. The prosecution has to merely allege, but there's no need for a proof at this stage.
Yes, Your Lordship. Your Lordship, if we look into the matter, this is a matter of as per allegations of the NIA, this is a matter of criminal conspiracy, and all of them have conspired for agitating war and communal violence against the integrity of the nation. But in the cases of criminal conspiracy, the Council do acknowledges that circumstantial evidences play important role. But in this instant matter, we are not provided with any such circumstantial evidences, because if you look into the matter, they were all collected at a place and they have not started the communal violence. It is a dungeon community which has started the violence. And if we look into the matter, they are saying that their community, the dungeon community, has started the violence because of the hate speeches. But the hate speeches are not backed by any authenticity. The Council would like to direct your Lordship to the Moot para 10, where it is written that the inflammatory speeches given by Miss Dora and Miss Brownie, where they are calling the people of other communities as cockroaches and leeches, the origin of that video is yet not traced, and the Council would like to emphasize that these videos henceforth does not possess any legal value as per the section 65 of the IT Act. The origin of video as because under section 65 of the IT Act and Indian Evidence Act 2, it is said that for admissibility of any electronic evidence, it must be backed up with the certificate or any authentic authority. But in this instant matter, even the origin of video is not yet traced. Therefore, the Council humbly submits before this honorable court that petitions are maintainable based on the facts that it is indeed a matter of grave injustice and the public good at large, and hence maintainable.
Council, are 65 certificates given in criminal trials?
Pardon, Your Lordship.
I believe the point you're making is a matter which is to be looked into by the forensics, and is a matter that the trial court will look into. If these videos are authentic or not authentic. At this point in time, the investigative agency alleges that these videos are authentic. So you make an application before the special court NIA to send them to forensics, or to send them to any other agency for an impartial examination, and that will determine whether the videos are authentic or not.
Yes, Your Lordship, but yes, Your Lordship, but if we look into this instant matter, we could see that it's been 5 years. We have already appealed to NIA court. We have after that appealed to the High Court. It's been 5 years. If for having this for having any substantial proof, NIA should itself come up with some substantial proof. They for
Counsel
5
is-
years they cannot just.
Counsel,
Yes,
is
Your
delay in completion of trial by itself a ground for grant of bail? Do you have any authorities to say that under Article 21, court has released somebody pending trial on bail because of delay in completion of trial? You can assist us in that.
Your Lordship, under Article 21, speedy trial is also included.
Yes.
And in this, speedy trial is also included, and
Starting from Husainara Khatun, recently, is there any judgment of the Supreme Court where somebody has been granted bail in an offence charged with that somebody was charged with an offence under UAPA, and the court granted bail because of delay in completion of trial? I believe there would be some judgments on that aspect also. It's a fair point you're making. See, 5 years is too long a period to keep somebody in trial. And from what you tell us, the trial is still going to take a long time to complete. So maybe you can assist us with certain judgments on that aspect. Otherwise, we'll tell the trial court to expedite and keep you in custody till then.
With the permission of the Lordship, the Speaker too would like to refer to the case of Sadiq versus State of Madhya Pradesh, in which it was stated that the magistrate would not be competent to extend the time of investigation in UAPA cases, and the Supreme Court in this very case overturned the decision of the High Court, which did not grant the bail. And also to mention the
Sadiq was the
clause 43, clause 2, subclause B, the maximum period of investigation without filing a charge sheet is given 180 days, which has crossed by a long time.
That's Sadiq is a judge, is a authority on the proposition that the time contemplated by Section 167 CRPC will apply to even an investigation done by NIA. You're right on that aspect. However, your case is different. Here, there are people who are facing trial, which is after charge sheet. They're an accused now. They're facing trial. So therefore, 167 is not an issue in this case. Here, your grievance is non-completion of trial. So therefore, anyway, to my knowledge, I believe there are certain judgments also where charge sheet was filed within 90 days, but trial has taken some time. We'll probably ask one of our law clerks to assist us in that.
Your Lordship, the Council would like to refer to the case of Soma Chakravarti versus State, in which it was held that when there exists a strong suspicion, then only the prima facie evidence is to be considered in the case of bail matter. But in this instant case, if you look at the prima facie evidences, they are not. They do not prove the fact they want to prove beyond the reasonable doubt.
Counsel, Soma Chatterjee case that you're citing, did it deal with an offence under IPC or under a special act?
Your Lordship, the Council, for the time now, the Council could not recall it, but the Council would like to deal it later on after referring to their compendium.
Yes, just for your information, the reason I'm asking this is because the special act contemplates a different scenario for grant of bail. The threshold is very different, unlike an IPC offence. So that is a material distinction. Please proceed.
Your Lordship, the Council would, if Your Lordship is satisfied with the arguments, the Council would like to deal with the third issue.
We've heard you. We reserve a judgment on our satisfaction.
Judges never indicate satisfaction piecemeal before the conclusion of the arguments. So we'd rather refrain from doing that.
Your Lordship.
Anyway, go ahead.
Your Lordship, the issue third that is present before this honorable court is that whether imposition of superior liability responsibility on Mr. Duffy is valid or not. And the Council humbly submits before this honorable court that allegations of bribe on Mr. Duffy are baseless because it is not humanly possible to track each and every comment or post made on such a huge platform. Therefore, the automatic system is being installed by Mr. Duffy, which shows the due diligence paid by the platform of Twitter. And later, when he got to know about the post, he sent it to the review committee, which didn't find it against the policies of Twitter. Anyhow, since a balance is to be maintained between freedom of speech and expression. Your Lordship, under the Section 79 of IT Act, we have got a safe harbor provision that grants conditional immunity to intermediaries from liability for third party acts. And the council for the same would like to refer to the case of Avish Bajaj versus State of Delhi, popularly known as Bazi.com case, in which an amendment was made and which ensures that intermediaries receive protection from liability under any law for time being in force. The amendment was there to ensure that the intermediaries receive the safe harbor protection as long as does not initiate the transmission, select the receiver of the transmission, and select or modify the information contained in the transmission, and observes due diligence while discharging the duties. But in this instant case, Peter didn't initiate any transmission, selected receiver of the transmission, and select or modify the information contained in the transmission. Also, Your Lordship, the Council does acknowledges the restriction that has been posed on this section under subclause 2 and subclause 3 of the Act. And the sine qua non for the same is that knowledge of post. Furthermore, Section 79(3) envisages a notice and takedown regime, wherein the intermediary is required to take down unlawful content upon receiving natural knowledge of its existence and when it is backed up by the court order. Thus, an intermediary is only required to act upon receiving a court order or a notification from the appropriate government or its agency. The intermediary is need not to require to exercise this discretion if it is not violating the policy of that very Peter. But in this instant matter, Mr. Duffy was not aware of any such post, although the mechanism of Peter does detect any prohibited post. Also, the post was later on detected by the review committee, and they does not find it to be violating the policies of the Peter. If the NIA have substantial proof to prove that actually the speeches were against the freedom, were abuse of freedom of speech and expression, and they need to be taken down, then NIA could have come up with a court order to take them down. The petitioners were merely executing their right to freedom and speech of expression. Therefore, I humbly submit before this honorable court to exempt Mr. Duffy from his superior responsibility. Your Lordship, if Your Lordship is satisfied, the Council would like to conclude by putting forth some contentions.
Yes, please
Just
do.
one. Sorry.
Yeah, sorry.
Also, just one question. So the proposition you're canvassing now is that in a scenario where the country is plagued by riots, an intermediary such as Peter is not required to take down any post which arguably may be offensive unless and until it receives a court order or a request from the investigating agency?
Yes, Your
There is
Lordship.
so there is no requirement to self-regulate or govern. Why do you have a review committee then?
Your Lordship, they had a review committee, and they actually reviewed the post, and according to their policies, they didn't find it offensive. And the Council would like to refer to the case of Avish Bajaj again, and in which it was held that if if intermediaries comply with the law of land, then then they need not to be held liable for their act. So in this
Also, what
instant
was the
matter,
post in Avish Bajaj case?
the Council, pardon Your Lordship.
What was the post in Avish Bajaj case? Here, the post is a video clip showing people beaten up and a note that we should replicate what is being done. In Avish Bajaj case, was the post even remotely similar?
No, Your Lordship, the post was not similar, but definitely the liabilities, but the context and the scenario of liabilities was similar, because in that very matter, the court, the owner of that very Bazi.com website was held live, was arrested for the post that was being posted on his platform by some other person, an IIT Kharagpur student, regarding of a porn movie. But in this instant case, and the two cases are in similar. The council is treating them similarly, because in this instant matter also, the Peter doesn't initiate any of the post. It is just like some other person and their user has put up a post on their platform, and they do have a review committee which actually reviews the post according to their policies, and they also abide by the law of this land. In case if the court would have given them order, they would have taken it down.
There is one factor which you need to answer. So what it says is Mr. Duffy was arrested for not removing the post. And if you see the last line of the paragraph, review committee did not find the post to be against the policies of Peter, and hence the same was not removed, which means apparently the request for removal was made and it was declined. So now what do you say in that context? When the investigating agency or the prosecuting agency makes a request for removal on account of post being threatening, creating communal violence, or of course violence resulting in deaths, then is refusal not contributory factor?
Your Lordship, the Council would like to take the benefit of doubt of interpretation in this very Moot proposition, where it is written, he stated that review committee did not find the post to be against the policies of Peter, and hence the same was not removed. Your Lordship, Mr. Duffy was arrested for not removing the post at the time they were posted. He was not given any court order regarding the same to remove the post. And when he was presented before the NIA court,
we are going out of facts. We are going out of facts. Your note does not say whether there was an order of the court or not. What it says is you declined to remove because your policies were slightly different. And therefore, as per your policy, you chose to follow your policies rather than the law. Now, we do not know because this is not a stage, it's an issue where the grant of bail is under consideration. Therefore, facts need not be proved by the prosecution. It's not a trial where the charges will be proved. It's a bail position, the stage. And therefore, nothing has to be proved. All that has to be seen is whether a serious charge is made out or not, and there is something to indicate yes.
Your Lordship, the Council would again like to put the contention that when he was presented before the court, he was asked the reason for not removing the post. So he claimed that he has not removed the post because of such reason. It is like in the Moot proposition, it is nowhere mentioned that he was asked to remove the post. It is just merely like written that he didn't prefer to remove the post because of such reason.
Oh, yes, when you say I would not remove because of my policy, that means you were asked to remove and therefore you declined. Otherwise, why would you consider that non-removal? But anyway, that's the point which you have to answer, that you had declined to remove as per your note. I'm not going beyond your note. So let's keep within the note, and then if there was a request for removal as it appears to be and you declined to remove, then what will happen?
Your Lordship, to actually deal with this issue, the Council would like to clarify the certain facts in this instant matter. Your Lordship, in the Moot proposition, the Council would like to state the fact as a few facts is that when the videos were surfaced on the Twitter platform, the CEO of the Twitter was arrested under the UAPA Act because such post was made on his account, and he didn't pay the due because as per the NIA the Peter didn't pay any due diligence, and they should have removed it even before the court order would have come. That's why he was arrested. And after that, when he was presented before the court and where he was asked, where the company was asked and held liable for the same thing, the Peter has stated that we have not removed the post because it is not violating the policies of our our policies are not being violated in this instant matter. That's why we didn't remove the post at that time they were surfaced. If there would be any court order and they were given chance to actually
that's not mentioned here. That's not mentioned here.
Your Lordship, it is nowhere mentioned in the Moot proposition that any court order or any notification was sent to the Peter.
Right.
regarding
So,
the
right, therefore, your answer doesn't say that there is no court order. Your answer says because it doesn't meet our policy, therefore. So, your policy cannot be above law.
Your Lordship, the Council would like to refer some case laws in this instant matter. The first case is regarding the Ram Manohar Lohia case and the Kedarnath versus the state of Bihar case. In Ram Manohar Lohia case, it was stated that public order, and there is difference of public order and law and order. The post that has been circulated that could actually violate that could actually enrage the law and order, but it couldn't affect the public order. And that is not the restriction mentioned in the article subclause 2 of Article 19. Further, in article in Kedarnath, it was held that that any of the hate speeches must be having some conduct backed by it. Otherwise, they won't be held liable for the same. So, therefore, the council pleads that that Mr. Diffie should not be held liable for this very instance.
Is there any time left, or is the time up for this team? Council, you can just wrap up your submission, sir.
Much obliged, Your Lordship. The council seek an extension of few minutes. Just for conclusion, Your Lordship.
Fine. We've heard your submissions. Maybe your co-counsel can assist us now. Thank you.
Much obliged, Your Lordship.
With the permission of the respected lordship, the council would like to move to the second issue mentioned in this case, that is for granting bail to all the 5 accused. So, after 2000 was of the leadership of Mr. Misra, Ms. Brown. Am I audible?
No, you're not audible.
You're not audible.
There's been some problem with the voice.
Am I audible to everyone?
Yeah, at the moment, yes.
Your Lordship, the council request if you could pardon us for few minutes. The speaker too is facing some network issues.
Am I audible now to everyone? Am I audible?
Yes, you are. Yes,
Okay,
you are.
Sorry for the interruption. There were some technical issues with the software. As I said, as the facts stand, after on the 21st of
of the 21st of November 2017 in the celebrity rally at the Peace Ground of Mayanagiri, which was organized under the leadership of Mr. Park, Ms. Dora, and Ms. Brownie. All the three were arrested by the NIA on 1st of December 2017. Now, before moving forward with the argument in this instance, the council would like to again reiterate the fact that since the arrest of the said people on 1st December 2017, it has been about 5 years and still no charge sheet has been filed in this case. Now, as the contentions of the respondents stand, in this very instant, they claim to have a prima facie claim against the involvement of these parties in this instant case under the said section 43D clause 5 of the UAPA. And that having a prima facie claim means that divulging in the merits of the case is the violation of the prima facie rule under the UAPA. However, there are some of the arguments that we need to consider in this case. According to the section that the court may deny bail on the pursuit of the case diary under section 173 of the CRPC, the section 173 of the CRPC refers to the report submitted by the investigating officer on the completion of the investigation. If the bail is denied by the lower courts under this section, this indicates that the completion investigation has been complete. And if that is in fact the case, why has the investigating agency not been able to file a charge sheet in the last previous 4 years? And on what grounds are they justifying this delay? Moving forward, because as I mentioned before during the clarification, because in this the section of 43D clause 2 subclause B itself, the time limit regarding the lapse of time for the not filing of the charge sheet has been set to an upper limit of 180 days, which includes all the extension that has been legally provided in this act. Moving forward, it is.
What's your basis of assuming from the agreed statement of facts that charge sheet has not been filed?
There was a clarification provided regarding the Moot proposition to after the to all the participants. In that clarification, it was clearly stated that charge sheet has not been filed.
I see. Okay.
Much obliged, Lordship. Moving further, my clients have been in custody for almost 4 years now, and it is humbly submitted before the court that from now in this instant we cannot only rely upon the prima facie evidence that are being talked for the last 4 years to judge this bail application. This is completely arbitrary and in nature and violates the right of speedy trial, which is an extension of Article 21, because our clients have been denied the right of trial from the last 4 years because of the not filing of the charge sheet. As I also mentioned in the authority cited of the Sadiq case, that the courts do not have the are not competent to extend this time limit as per the Supreme Court guidelines. In the present case, as mentioned earlier, and as the facts stand, these are in fact overwhelming circumstances where such a long time has been passed, which is not have been seen prior to this case. Moving on to the prima facie evidence that are being repeatedly referred to here, the video of the inflammatory speeches have not been proven to be legit. Neither has its source been traced, nor the speeches have been corroborated by any witnesses. Hence, it cannot be said to be a strong prima facie evidence that is enough to incriminate the accused person. Now, the problem of this with evidence is that although it might have been considered to be a prima facie evidence earlier, the investigating agency from that time had a period of 4 years to track down its origin, or in fact gave us forensic evidence of its authenticity itself, which has not been which has also not been done in any of the hearing, neither in the High Court nor the NIA Court. Also, the question of authenticity of the video has not been dealt by the agency, because in the 21st century, it is very easy to morph a video and incite such violence. Now, moving to the part where the journalist Miss Vishy has been arrested, the interviews that are being talked about here have no relation with the incident, as it was published before the incident, as mentioned in the clarification for the Moot proposition. And it is also to be understood, if the interview had any direct nexus with the events, the violence would have begun way before the rally had started, and these violence should could not have been waited till the starting of the rally. Hence, it proves that both the events are completely unconnected to each other. Moving further, it is also to be understood that as a responsible journalist, Miss Vishy had to publish the interviews of the three people who are supposedly the voices of the suppressed people of the Gaon community, and their faces against the oppression that is put against them. The views of them, these people regarding the same, are torch bearing for their community, and are well under the preservation of their rights under Article 19(1) of the Constitution. In addition to all these facts, what we need to consider here is, which is very important, that the facts are completely silent about the content of these interviews, and hence it cannot be proved that the interviews contained anything that was inflammatory or inciting. In addition to this very fact, it must also be seen that Miss Vishy is mere a journalist and not the editor of the newspaper, which is it is not mentioned in the Moot proposition that she is the editor or has any authority over the final print of the newspaper, what goes and what does not go. If we take the same analogy and arguendo, that Mr. Duffy has been arrested on this basis on the basis of superior responsibility, why in this case has Miss Vishy been arrested instead of the editor of the newspaper? This clearly shows that the NIA investigation is completely misguided and completely works upon agenda instead of solid proofs. Hence, in no way the said interviews can be regarded as a strong prima facie evidence to incriminate the said people to the charges. Moving on, as my counsel already dealt with the issues of superior responsibility against Mr. Duffy to be invalid, I would move on to the next important argument, that is a chain of events that is being established by the respondents. The respondents are trying to establish a chain of events that is completely frivolous in nature. They are referring to a meeting that was alleged by the National Investigation Agency that took place at the house, but there was no evidence to corroborate this very point. It was completely, as mentioned in the Moot court itself, alleged point, and hence it cannot be treated as a part of a chain of evidence to prove any conspiracy whatsoever. Therefore, to sum up all my arguments, I would like to mention 4 points: that the right to trial of the accused have been curtailed in this case because of the delay in the charge sheet. Also, bail in this case, bail can now no longer be judged on the pretext of the prima facie evidence, although also the prima facie evidence are very feeble. And neither of the very important point to note here is that neither of the 5 arrested people have been a hindrance in this investigation. They have been fully cooperative with the investigation, and by no act or by no fact in the Moot proposition it has been established that the said people have the threat of tampering with evidence on being released or pose a threat of running away. Hence, it is humbly put forth in front of the court that the court shall grant bail to all these 5 people, and also ask the NIA to expedite their investigation and file the charge sheet as soon as possible. Moving further, if the
So I have a query here.
Yes, Your Lordship.
You are definite in your statement that there is no charge sheet filed, despite 180 days having lapsed. Despite 180 days having lapsed.
Yes, Your Lordship.
I mean, that is the ground. Then what is the point in arguing all over the world when this ground itself is sufficient to grant you bail? I mean, to get you bail, this is enough. Why do you have to run around for other things?
Yes.
So I really don't believe that is the sum and substance of this entire case. I think it proceeds on the premise that the issue of charge sheet has to be kept aside, and then the assessment has to be made. But if you accept the fact that the charge sheet has not been served, then why unnecessarily waste your time on other arguments?
Much obliged, Your Lordship. But petitioner humbly puts forward that in fact the clarification clearly mentions that the charge sheet has not been filed, and there was no clarification that this fact is not relevant to the case. Adding to that, the other arguments are in response to the memorial of the respondents about the argument that they have put forth in their written memorial.
I don't know. We as lawyers will never put forward any other argument except this one, that there is no charge sheet. That's good enough to get the bail. Why should you unnecessarily argue? But I am not able to understand, because this whole paper of yours does not refer to charge sheet having not been served. So if the charge sheet is not served, then there is the issue of this question being there, whether bail shall be granted to all the 5 persons. And then the fact is that the trial court has, at the trial stage, the bail has been rejected. Why would the bail be rejected if the charge sheet was not filed?
Your Lordship, I believe the respondents would be telling why there should be a bail should not be granted if the charge sheet has not been filed. From the side of the petitioners, we are well within our rights, because
there is a question. If there is no dispute about the fact that the charge sheet has not been served, filed in the court till date, so then where is the question of there being any dispute and clarification? I don't know. My premise is, my assumption was that the whole thing proceeds on the premise that there is no, that the issue of charge sheet has to be kept aside.
Your Lordship, the charge sheet had been filed. Indeed, Your Lordship, but if the charge sheet had been filed, this would have been a complete trial, and we had to come with evidences which were not provided. So, looking at that, charge sheet not being filed makes sense, because nothing of sort of any strong evidence is provided to pursue the case. So, in that matter, we are very sure and we are confident.
The charge sheet has to be filed in the court within 180 days. The relevant evidence being provided to you in the charge sheet is thereafter. But the point is, the charge sheet has not been filed in court, then you are absolutely entitled to bail. Then where is the question of going around the bush and perhaps raising all kinds of arguments? So my assumption was that this proceeds on the premise that there is no charge sheet. The issue of charge sheet has to be kept aside. And then the matter has to be seen. I guess my fellow judges would agree with that.
Yes. What my senior friend has been saying is right. If the charge sheet has not been filed, there is no issue for waiting for any other argument to be done. He is the remedy in accordance to the provision of section 167 of the CRPC to apply for the bail instead of waiting.
I think someone has committed a mistake somewhere.
Yes.
So let's proceed on the assumption that the issue of charge sheet is aside, and we don't have to go into that. Meaning thereby that we have to assume that the charge sheet has been served, and then what happens? That should be the position. Otherwise, what is the point?
Your Lordship, if Your Lordship allows, the Council would like to answer this question.
Yeah, go ahead.
Your Lordship, the Council acknowledges that under Section 167 we are eligible for getting this default bail. But the same section in a subclause also provides, also under Section 439, the High Court has got this power to reject the bail if they believe, even if the charge sheet is not filed, if they believe that there are substantial evidences available, and prima facie evidences are.
The charge sheet has not been filed. Where is the issue of substantial evidence being there?
Yes.
Your Lordship, the prima facie evidences that NIA is providing to the court, NIA court and the High Court.
But that is only with the charge sheet after investigation. It can't be before charge sheet.
Your Lordship, the
charge sheet is something which contains the entire evidence.
It contains the investigation which has been done by the investigating agency. It is the compilation of the investigation.
So if the charge sheet is not there, then there is no evidence, obviously.
Yes, Your Lordship, but the subclause 5 of the default bail provision again talks that it is the discretion of the court that if they want to reject the bail, if they are provided with some prima facie evidences and they can be reliable. And for the same, the Council would like to refer the case of Soma Chakravarti versus State, in which it was held that charge may although be directed to be framed when there exists a strong suspicion, but it is tried that the court must come to a prima facie finding. In this very instant case,
it doesn't happen in case of default bail. I think there is an apparent mistake.
The council completely agrees with the points of the learned judges, but at this point of the hearing and the competition, after all the events where we have considered that charge sheet has not been filed, changing the facts now would be unfair for both the parties. So, if the respected lordship would consider to be the facts to remain same, that would be beneficial for us.
That would be that no charge sheet is there. Or
yes, your lordship. Because our whole arguments and whole case summary has been based on this fact that the charge sheet has not been filed, both for the petitioners as well as the respondents. So changing at this juncture would be unfair for the participants.
No, that's fair enough. I am not saying it is fair or unfair, but then the whole arguments do not have any meaning. That's what I'm trying to say. Anyway, you may argue, but it's meaningless.
We completely get your point, your lordship. With the permission, we'd like to move to the next issue, the issue 4, and would like to sum up very quickly. I don't think I do not have time left. So in the issue 4, that is deals with the charges of UAPA that are unconstitutional. It is humbly submitted before the court that certain sections of the UAPA are unconstitutional and violate the right of equality under Article 14 and the right of freedom of speech under Article 19(1)(a) and the right of life with dignity under Article 21 of the Constitution. The council would like to contend that the UAP lacks substantive and procedural due process. The main loophole in the UAPA is the inadequate insights on the due process. The present act gives absolute power to the government of India to declare any activity as they deem appropriate as unlawful and publish them in the official gazette. The definition of the word terrorist act under this act is very vague. Most of the time misused by public officials. The meaning of Terrorism Act in UAPA is obscure. Revisions of the UAPA in 2019 have enabled the union government to declare a person as terrorist without giving a fair chance to represent himself in front of the judiciary. The act also permits the detention of the person found to be engaged in unlawful activities without being in any legal protection for 180 days, which is completely against the personal liberty of the individual. Not to mention that it also allows the security agencies to take the perpetrator under police custody for up to 60 days without any real and substantive evidence against him, only based on alleged evidence presented by the security agency handling the case. Moving forward, it is also mentioned in the act that it is entitled in some cases that it is entirely up to the discretion of the court whether the accused will have a physical courtroom proceeding or will take the virtually in the in camera proceeding. This will create an unfair situation for the accused, as the court will create circumstances under which proceedings will take place, rather making it a trial that is public, as what usually happens in the criminal justice system. Moving forward, the Indian criminal jurisprudence labels a person innocent until proven guilty. Justice Krishna Iyer, while deciding this case of state of Rajasthan versus elucidated the law regarding bail as the rule is bail, not jail. However, Section 43D, Clause 5 of the UAPA acts as an exception to the above-mentioned rule, which gives it a unique authority to the courts of rejecting bails. This process empowers the government to suppress the voices of dissent. Voices of dissent. Talking about the voices.
Sorry to interrupt you. Have provisions of UAPA been considered by this court in some earlier judgment and upheld? Are you aware of any judgment? Because then your argument should be as to why is there a need for review of those earlier judgments which have upheld the constitutionality of UAPA provisions. Is there such judgment to your knowledge?
Your Lordship, there's a judgment. We do not have its citations mentioned, but with the permission of
You
the
mean Kamtar saying all those judgments did not test the constitutional validity of provisions of UAPA? Are you aware?
Pardon, Your Lordship, I was not clear on the last one.
No, I'm saying, are you aware of any judgment of the Supreme Court where constitutional validity, the same grounds you're urging before us today, have already been considered and adjudicated at length before by this court?
We do not have any authorities at this point, but we would like to answer it in the rebuttal round if it pleases the court.
No, there is a Supreme Court judgment upholding the validity of UAPA. UAPA has been held to be a valid law. So now you have to proceed on that premise. That's why I'm saying the entire framing of the issues over here has to be based on the premise that there is a charge sheet. Otherwise, it's meaningless. The law has been upheld. Then how do you say the charges can be unconstitutional? And charges will only come when the charge sheet is filed. You say charge sheet has not been filed.
Your Lordship, as mentioned by you, that these charges increment to point towards Article 50, Section 15 of the UAP regarding the terrorist point. So we are on that assumption, we are challenging those very sections of the UAP, very charges of the UAP. Because in certain the charges that are being provided in the clarification are just regarding the criminal conspiracy and the procedural under which the arrest is done. No other charges are mentioned that has been placed under the UAP. With the permission, would like to move to the last contention. That is, the UAP is in direct infringement of the free speech. Dissent is an integral aspect of the right of free speech under Article 19(1)(a), as interpreted in Maqbul Rajkumar Pandey. Maqbul. In the case of Maqbul Fida Hussain versus Rajkumar Pandit, the imputed law is also liable to struck down as the same is violative of fundamental right to free speech and expression guaranteed under 19(1) of the Constitution of India. The fundamental right of dissent and it being part and parcel of the free speech and expression makes it inalienable except the circumstances mentioned in under Article 19. The Honorable Supreme Court in the case of Romesh Thapa versus State of Madras analyzed the importance of free speech and expression. Therefore, to conclude this argument, the council would like to state that it is high time for the judiciary or the lawful authorities to take notice of the glaring problem of this legislation. If the authorities do not address the problems in a timely manner and the purpose of the legislation will turn from anti-terror to anti-dissent, it is humbly pleaded before the court that the court shall declare that these said charges to be unconstitutional. With the permission of the lordships, the council would like to move to the prayer.
So can you just tell us briefly what are the grounds on which a constitutionality of a provision is challenged, just in law?
The constitutionality of a law can be challenged if it hurts the basic structure of the constitution, or any law in the Indian constitution is against any law in the Indian constitution. It can be termed to be unconstitutional, or if it does not follow the test of reasonableness or intelligible differential laid in Article 14 of the Constitution.
So what you're trying to say is
issue number 4, please look at issue number 4. It doesn't raise the issue of constitutionality of law. Whether the charges of UAPA are constitutional, not the law. So why are you going into that?
We did mention the charges that we were challenging regarding the Article 15, the definition of terrorism, and also the 43D Clause 5, where the court the power is to reject bail on the basis of prima facie evidences, and other similar other charges also that are stated here. So we did challenge the charges.
Please hold it. Please understand. The issue is whether the charges of UAPA are constitutional. The charges. So whether they are constitutional or not, that's the issue raised here. Item 4. It doesn't talk of whether UAPA is constitutional or not. It doesn't say that. So why are you going into that question of UAPA being violative of Article 19 or something like that? That issue is not here.
Yes, Your Lordship.
The charges.
Yes, Your Lordship. We are not challenging the UAP as an act as a whole. We are challenging the charges that we have said some sections of the UAP that are unlawful, and we are challenging them on the basis of the state arguments mentioned.
Okay.
Much obliged, Your Lordship. Wherefore, in the light of the arguments raised and authorities cited, may this honorable court be pleased to declare that all the petitions filed are maintainable, grant bail to all five of the accused people, also declare that the imposition of superior responsibility on Mr. Duffy is invalid, and declare the said charges of the UPA unconstitutional, or pass any other order it may deem fit in the interest of justice, equity, and good conscience, all of which is humbly submitted before this honorable court. That the petitioners rest their case as far as this round of their pleading. It was honor and pleading in front of the court. Thank you.
May it please the Honorable Court. This is Counsel 1, and I, along with my co-counsel, will
Your voice is not clear.
We can't figure out.
We can't hear you.
Can the counsel be heard?
Now we can.
Right. Can you please confirm if I'm clearly audible?
Yes, you are.
May it please the Honorable Court, this is Counsel 1, and my co-counsel represent the respondents in the present matter. The counsel seeks permission to collectively refer to the bench as Your Lordships.
Yes.
Much obliged, Your Lordships. Your Lordship, the counsel seeks permission to move towards the issues. Much obliged, Your Lordships. Over the next few minutes, I will make two submissions to this Honorable Court. First, that the petitions filed are not maintainable before the Honorable Court. And second, that bail should not be granted to the petitioners. My co-counsel will address the remaining two issues. The counsel seeks a final permission to begin with her first submission.
Please, go ahead.
Much obliged, Your Lordship. Your Lordship, the counsel humbly contends that the petitions filed are not maintainable before this Honorable Court. Your Lordships, in the present case, there are three petitions which have been filed by the petitioners, and the counsel, by way of her contentions, by way of her submissions, will prove why they are not maintainable. Your Lordship, regarding the first case, which is the SLP, which has been filed, the counsel relies on the precedent of Preetham Singh versus the state, which is a 1950 case on the page 1 of our written submissions, wherein this Honorable Court held that the power under Article 136 is to be exercised sparingly and only in exceptional cases, and it is open to the court to question the propriety of the leave granted. And if there is no gross violation of the rights of the petitioners, then bail shall not, then the special leave petition should not be entertained. In the present matter, Your Lordships, there is a prima facie case being made out against the petitioners based on the investigation which is carried out by the NIA. Therefore, the charges pressed against the petitioners are grave in nature, which constitute crimes such as sedition, Section 124A of the IPC, and Section 18 of the UAPA, which is the punishment for criminal conspiracy. Your Lordships, the council submits that in light of the greater welfare of the public, so that no risk is posed on the general public's right to life under Article 21, both the NIA courts and the High Court did not grant bail to the petitioners, which should be upheld, and the special leave petition should not be entertained. Your Lordship, the reliance is placed on the case of Kedarnath versus State of Bihar 1962 case, wherein it was held, and as I would quote, when no law confers a statutory right to appeal on a party, Article 136 cannot be called in aid to spell out such a right. The power under Article 136 is extraordinary, which is to be exercised in rare and exceptional cases and principles. Your Lordship, since there is no gross violation and a prima facie case has been made out on the basis of videos, on the basis of hate speeches which were made by the petitioners, the special leave petition for granting of bail should not be maintainable, Your Lordships, in the present matter. Your Lordships, moving towards the maintainability of the petition filed by the United Journalist Organization, which is the PIL.
Yeah. Sorry, Counsel, on the maintainability of maintainability of bail applications under Article 136. So your proposition is that continued detention of a person who's been charge sheeted even after 5 years facing trial is not the gross violation. I mean, in my personal view, it is the grossest violation to deny that person a right to even come to this court.
Indeed, Your Lordship. Your Lordship, had the present case not been a UAPA case, this had been a very gross violation. However, since the charges are extremely grave and severe in nature and has caused death at a large scale, and since the charge sheet is not filed because the NIA is still looking for more conclusive evidence, therefore, in light of the greater welfare.
Counsel, mere invocation of UAPA or any other special act will not itself dilute the fact that this is extremely gross, and perverse the fact that somebody is in custody. If this case is so important to you, you should have completed the trial by now. It's because of you the trial is going on for 5 years. To say that the petition is not maintainable is one thing, and to oppose the petition on merits is another thing. Your submission is that the petition is not even maintainable, that the petitioner has no foot through the door also to come to this court, despite the fact that his bail applications are rejected, despite the fact he spent 5 years in custody.
Indeed, Your Lordship. Your Lordship, since even firstly, the two-fold submission that the council has is that firstly, this is a very serious and heinous, and if is enlarged, then it would lead that then there is a risk of further communal violence taking place, because Your Lordship, there is a prima facie case which exists in the present matter. Your Lordship, the council would like to place reliance on the case of on the 2018 case of NIA versus Zahur Ahmad Shah Batali, wherein bail was not granted for 3 years, and in the same case, the Honorable Supreme Court held that bail proceedings in any special enactment, such as UAPA, the courts are duty bound to refuse bail when there is a suspicion of a prima facie case being made out, and until unless the investigation is completed, the provision of which is under section 43D5 of the UAPA, the petitioners can be detained because of such heinous and serious nature of the crime, the charges of which have been pressed against them.
So, Mr. Counsel, what do you want to say in respect of that? If you have the reasons to believe that the person, after having granted the bail, would repeat again the same commission of an offence, so either he should not be granted the bail, despite this fact that the charge sheet has not been filed after the lapse of 5 years. Don't you think that again there is the right of the accused persons also is going to be influenced?
Indeed, Your Lordship. Your Lordship, the right, there indeed is a right that the petitioners have under Article 21, which is being infringed. However, it has to be balanced with the Article 21, the right to life of the general public as well. And if they are enlarged on bail, if the petitioners are enlarged on bail, then it will pose a greater threat to the general public, wherein there is a possibility of more incitement of communal violence, the charges of which the petitioners have been charged with.
So you mean to say that,
and which is why to balance.
You mean to say that in anticipation that he would repeat the same violence, he should not be granted the bail. There has been other way with the judiciary to impose the conditions while granting the bail. The court has the power to impose certain conditions that he should not repeat the same offense again. But merely on the basis that we've been anticipating that he will repeat the same offense, and he should not be granted the bail, that is not correct. If a case has been made out on his part, look, after the filing the charge sheet, whether there has been a merit in the allegation or not, it is again the matter of trial. It has to be proceeded after the charge sheet is to be filed and after the framing of the charges. But so far as the bail is concerned, the court is bound to see whether the prima facie case has been made out or not. And if the charge sheet itself has been filed after the lapse of 5 years, it means there has been some doubt on the part of the investigation as has been done.
Indeed, Your Lordship.
So why should not have given the benefit of the bail? What do you have to say in respect of this point?
Your Lordship, there are the twofold contention the council has to answer Your Lordship's question is firstly that the charge sheet in nearly 4 years, nearly 5 years has not been filed because of the large scale violence and finding of more conclusive evidence. But secondly, to more specifically answer your question, the bail is not granted when the triple test of the bail is taken into consideration. That is, that since the petitioners are influential personalities in the nation of India, there is a possibility that they tamper with the evidence which is already present. There is a possibility that they might influence the witnesses, and there is a great possibility for the petitioners. Am I audible? Can someone please confirm if I'm audible? Can the courtroom master please confirm?
Yeah, you are audible.
Now you are audible, yes. Okay. Right.
Can the courtroom master please confirm if I'm clearly visible and audible?
You are audible and visible.
Sincere apologies for the technical glitch, Your Lordship. Your Lordship, also the third, apart from the triple test, the third contention the council has is that the lower courts, which is to say the lower courts, the NIA special courts, and also the High Court, also rejected the bail in the first instance, even after repeatedly being applied for the bail. There must have been something serious because of, and they must have found something heinous because of which the bail would not have been granted, and which is why this honorable court should also upheld the decision.
Point is 180 days. The charge sheet not being there, he is entitled to and court is obliged to grant bail. You have to get over this.
Indeed, Your Lordship. Your Lordship,
is there any provision which says, despite the charge sheet not being filed for 180 days, still the bail should not be given? I don't think there is a provision.
No, Your Lordship, there is no such provision. However, the application for bail, especially when the petitioners have been charged under a special act, should have been filed. If before the charge sheet being filed, and there is
charge sheet has not been filed, so the application was before the charge sheet.
What do you
Your Lordship, the application for Your Lordship, the application for default bail has not been filed by the petitioners before the
doesn't matter. The bail application is before filing of charge sheet. Is it not? You are saying charge sheet has not yet been filed. So therefore, the bail application is before charge sheet.
Indeed, Your Lordship.
So they are entitled to under the law.
Indeed, Your Lordship. Your Lordship, at this point in time, the council submits that because of the heinous nature of the crime, because of the fact that it took place on a large scale, the charge sheet still hasn't been filed because there is more conclusive evidence which has been looked for. And by virtue of that, by virtue of balancing the rights of the right to life of the general public and the petitioners, the enlarging the petitioners on bail would pose a threat to the general public's Article 21, the right to life.
The prosecution should have filed. It doesn't matter. Prosecution should have filed if it was so serious. See, you're not being convicted. This is bail. Grant of bail is not conviction. So the trial can go on. You can still file a bail if you want to, and the charges will be tried. But the fact remains that you have not filed the charge sheet for 5 years. How can you possibly deny bail? I mean, I am aware of the fact you are seriously handicapped because. But the whole issue is no court in our country at least will support your cause.
Indeed, Your Lordship. Your Lordship, the council can only contend that the fact sheet is silent why the charge sheet has not been filed, but with what the council can make out, just because it is a large-scale violence and more conclusive evidence has been looked after. Therefore, just to balance the rights of the general public, bail should not be granted to the petitioners. Your Lordships, your permission. Moving towards the maintainability of the petition, which is filed by the...
Mr. Counsel, you have raised two issues in this argument. First, that the bail application is not maintainable before the Supreme Court after the rejection of the bail by the High Court and NI Court. Okay. Second issue, what you've been raising that because of some more conclusive evidence to be collected by the prosecution agency, the charge sheet has been delayed. You've been taking this point. So
Your Lordship,
your issue in respect of the maintainability of the bail is not sustainable. Because still you can oppose the bail. They are taking the ground that the bail has been rejected by the High Court in the merit after having found some sort of elements in respect of the allegation as has been made. You can oppose the bail before the Supreme Court, but you cannot say that it is not maintainable, isn't it?
Your Lordship, it is not maintainable because the High Courts and the lower courts have repeatedly denied the bail to the petitioners. And Your Lordship, there is no gross violation of any of the fundamental rights of the petitioners, since the fundamental rights of the general public under Article 21 also have to be balanced, given the fact that this is a heinous and a large-scale violence, and the investigation for more conclusive evidence will take time, Your Lordship.
So you want to say that an accused person does not have any fundamental rights? You want to say that, right?
Your Lordship, an accused person does have fundamental rights.
And then, what do you like to say about this?
Your Lordship, indeed, under Article 21, had this not been a case of the Special Act of UAPA, the petitioner should have been enlarged on the bail. However, since it is of such a serious and heinous nature, considering the fact that it would pose a threat to the general public if the petitioners are enlarged on bail, it is not prudent to release the petitioners on bail until the investigation is completed, Your Lordships.
So you would say that if any special enactment has been enacted by the Parliament, and whether it restricts that there should be the separate provisions to be followed in respect of the bail? It's not that.
Your Lordships, the Council believes that the NIA, being a specialized agency, is already...
CBI is also there, Enforcement Directorate is also there, but all the provisions for the bail have been seen. Even if you must have gone through the provisions of the PML Act 2002, what is prescribes that if the bail has to be considered under Section 45, then it is for the prosecutions to give an opportunity to establish whether the case has been made out or not. After that, court will consider to grant bail. But even that provisions also has been struck down by the Supreme Court after holding it that at the time of the bail, the merit of the prosecutions cannot be considered. It will be considered later on after filing the charge sheet. It is a matter of trial. It is a matter of evidence to be recorded during the trial. So what is to be seen at the time of granting the bail, whether the prima facie element of in relations to the that offence alleged to have been committed has to be seen by the court. Prima facie evidence.
Your Lordship, to answer your question, there are two submissions the Council would make. Firstly, that there is prima facie evidence in the name of videos and posts and hate speeches being posted and the newspaper publishings being in place. because of which a prima facie case can be made out, because of which they've been arrested and detained. Secondly, Your Lordship, the 5-year delay, the 4 to 5 year delay that has been seen in the present matter, Your Lordship, in order to track down the other people who are involved in the whole conspiracy, it is required that the 5 petitioners which are detained are should remain under the custody, and which is why just so that more conclusive evidence can be sought, and more and more people who are involved in this conspiracy can be tracked, it is a requisite that these people are in police custody at least until the investigation is completed, Your Lordships.
That is that.
The investigation continues for 20 years. They should not be released.
Indeed not, Your Lordships. The investigation is as expedite as NIA possibly could make it. Your Lordships, the Council believes that the investigation is as...
5 years is a long time.
Indeed, Your Lordship, 5 years indeed is a long time. However, unless and until the...
5 years is a pretty long time.
And Council, are they in police custody? Is that what you said?
Indeed, Your Lordship, they are in the police custody.
So they're not even in judicial custody? Where do you get that from?
Your Lordship, they only have been arrested by the NIA, and there is no mention of any judicial authority. There is no mention of any judicial custody in the fact sheet.
So you're just throwing the rule book out of the window here completely. Seems.
Your Lordship, however, the...
I mean, you're not to be blamed. You are at a disadvantage.
Proceed, Council.
You're not to be blamed. You are at a disadvantage.
Indeed, Your Lordship. Your Lordship, moving towards the maintainability of the petition filed by the United Journalist Organization, a PIL which has been filed, the Council submits that the PIL is not maintainable because there is no violation of the fundamental rights of Miss Vishy, Your Lordship. It was the interviews of Miss Vishy which played instrumental role in causing violence across the nation of India. Your Lordship, with reference to the factual matrix in the present matter, lakhs of people across the nation read newspapers daily, and when there is a clear possibility of people getting incited for communal violence because of the interviews given by influential people from a particular caste, such sensitive interviews by way of biased journalism should not have been published. However, Your Lordship, Miss Vishy did publish them in the local newspapers, taking the violence to villages as per the plan drawn by petitioners 1 to 3, and as has been mentioned in the fact sheet, to be found in the NIA investigation, which is why which finally led to the rise of communal violence. And third, Your Lordships, in the case of Gopal Das versus Union of India, which the Council relies on, which is a 1955 case by this Honorable Supreme Court, it was held that in order to invoke the jurisdiction under Article 32 of the Constitution to approach this court directly, it has to be shown that why the High Court has not been approached or could not be approached, or it is futile to approach the High Court, none of which has been established here by the petitioners, Your Lordships. Therefore, since there is no gross violation of any fundamental right of Miss Vishy, and the High Court, which is the alternative remedy, has not been exhausted, the PIL filed by UJO, Your Lordships, should not be maintainable. Your Lordships, regarding the maintainability of the third petition, which is filed by NGO Equal Justice...
Council, PIL is filed under which province?
Pardon, Your Lordship, could you please repeat?
PIL, the public interest litigation that has been filed, it has been filed under what province?
Under Article 32, Your Lordship, of the Constitution.
The Article 32, because there is an arrest and therefore 32 is maintainable.
Your Lordship, there is an arrest. However, this is a PIL which has been filed on the basis that Miss Vishy has been charged with the charges under UAPA. However, Your Lordship, when there is a clear prima facie case which goes on to show that Miss Vishy did publish articles which could incite people and which could entice communal violence because of the interviews given by these influential people and by way of the biased journalism which has been done by her, Your Lordship, even after considering that, even after considering the fact that that could incite violence, Ms. Vishy did publish them. And which is why she is rightly arrested, and which is why there is no need, that there is no fundamental right of hers which has been infringed in the particular matter, Your Lordship. Your Lordships, regarding the maintainability of the third petition, which is filed by the NGO Equal Justice, where a fresh investigation into the matter is demanded, the Council submits that NIA has qualified and specialized officers, it is a specialized agency, who carry out the investigation, which is fair and impartial in nature. Your Lordship, deeming it to be partial on the basis of caste of the constituting body of the NIA would be a sheer violation of the fundamental right to equality, which is guaranteed to every citizen of India by virtue of Article 14. The Council relies on the case of Magan Bhai versus Union of India, 1970 case of this Honorable Court, where it was held that mere speculation without concrete or substantial evidence that the petitioners are deprived of their fundamental right to fair investigation is not enough to invoke the jurisdiction of the court under Article 32. And relating it to the present factual matrix as well, Your Lordship, there is no concrete, no substantial evidence which has been made out by the petitioners to show that the investigation which has been carried out by the NIA, by virtue of it involving people of a particular caste, went partial or was not up to the mark, Your Lordship. Your Lordship,
what investigation or arrests have you made in respect of the people belonging to the Dungeon caste? The agreed statement of fact in paragraph 5 says that in a peaceful assembly by people from the Geon caste, a group of about 30, a group of people belonging to the Dungeon caste arrived with weapons and attacked Geon people. So this is in the admitted statement of facts. Now your arrests are made of all people who belong to the Geon caste. So therefore it appears that you've not done any investigation at all in respect to the people who started the violence in the first place. That's what is giving ammunition to the apprehension of all these NGOs that NIA is partial in its investigation. Why should we not transfer it? Secondly, you've not even completed it after 5 years, but we'll not take that against you.
Your Lordship, the Council submits that the fact sheet is completely silent on whether any person from the Dungeon caste has been arrested or not. However, since the Geon people, since the NIA, the National Investigating Agency, in one of its findings found out that there was a roadmap to the violence which was drawn when Perk, Dora and Brownie, three of the petitioners, sat at the house of the Perk, drawing the whole roadmap of how the violence has to take place, and which is why they incited violence by way of Miss Vishy being involved by publishing interviews, by giving hate speeches in the peace ground. By way of all of these activities, Your Lordships, there is an incitement of violence which has been done on the part of the Geon people. However, Your Lordship, to answer your question, the fact sheet is silent on whether the Dungeon caste people have been arrested or not. And on that, Your Lordship, the impartiality of the NIA should not, Your Lordship. That's what the Council believes. If Your Lordships are satisfied with the Council submission on the first issue, the Council seeks permission to move to the second issue for the next 5 minutes, Your Lordships. Your Lordship, the contention for the second issue is that...
I thought you answered both the questions.
Your Lordship, the Council will just conclude the second submission in a few minutes. The contention for the second issue is that all 5 people arrested should not be granted bail. The Council will make threefold submissions in order to affirm her contention. First, Your Lordships, that the petitioners 1 to 5 have acted and supported each other in furtherance of the violence. The first 3 petitioners, Perk, Dora and Brownie, drew the plan for the violence at the residence of Perk, as has been found out in the NIA investigation, which is on paragraph 8 of the Moot proposition. And the interviews were taken in furtherance of the same. In furtherance of the same, hate speeches against the Dungeon caste were also made. Duffy, also in furtherance of the same, supported this agenda by allowing such hate speeches to be shared on his platform, by not removing them, by not taking them down. Therefore, Your Lordships, the Council submits that the rights which lie under Article 19(1) have to be read with the reasonable restrictions which are mentioned under Article 19(2). And the right to freedom of speech and expression comes from Clause 1. the right to freedom of speech and expression comes from clause 1, but this right must be within the limits that have been enshrined in clause 2. And the petitioner's acts, Your Lordship, were continuously raising to fill hate, disaffection, and ill will. Your Lordship, an example to that is when Dora and Brownie referred to the dungeon caste people as cockroaches and leeches, and the way they should be treated as if the cockroaches are treated when they are found in our bedrooms. Your Lordship, this is a clear indication of communal violence being incited, because as cockroaches are being killed at homes if they are found in our bedrooms, that is exactly how the violence is incited in the present matter by the petitioner's posts as well, Your Lordships. Your Lordships, while it is necessary to maintain and preserve freedom of speech and expression, it is necessary also to place curbs on the freedom for the maintenance of social order. Your Lordship, an absolute uncontrolled liberty, wholly freed from restraint, for that would lead to anarchy and disorder, which is the case in the present matter, which did happen. Your Lordship, for Duffy, which is the CEO of Twitter, being aware of the menace of the communal violence in the society by virtue of the viral posts and by virtue of what is happening in the nation, Duffy still did not take down any sensitive posts on his platform. And as has been alleged by the NIA, it can be clearly made out that he took money from petitioner 1, and that he belonged to Gayon caste as well. Your Lordship, Duffy belonging to this particular caste, and as has been found out in the NIA investigation, taking money from the petitioner 1, colluding with the other accused, tried to further the violence and destroy the unity and integrity of Mindia. Your Lordship, it is submitted that in bail matters under UAPA, the courts are required by the statute to primarily focus on the merits of the case to determine whether or not bail should be granted. And as per section 43D5 of the UAPA, UAPA statutorily bars the grant of bail the moment it is shown that a prima facie case is made out against the petitioners, which is the case in the present matter, by virtue of the posts, hate speeches, and the fact that the posts were not taken down by Duffy. The authority on which, as has been stated by the council before as well, the respondent relies on the case of NIA versus Zahoor Ahmad Shah Watali, wherein the court laid down that if it is prima facie believed that the petitioners did commit the crime or in fact were involved in the conspiracy, then they could be arrested and they should not be granted bail for that matter, unless investigation is completed. Your Lordship, the council humbly submits that given the high possibility that the release of petitioners will further promote the violence between both the castes, they should not be released on bail. If the bench has no further queries, the council seeks permission to call upon her co-counsel.
So, Mr. Counsel, one query. What you have referred to the provision of 43D, that which makes that there is a bar for granting the bail to the persons who has been made an accused under the special law. So, what do you think? Whether, despite this bar, the person should not be considered to grant the bail? If the case has been made out on his part that there has not been his active involvement in the alleged commission of the crime, despite the bar, whether he should not be considered to give the bail? What do you think so?
Your Lordship, much obliged, Your Lordship. Your Lordship, to answer your question, firstly, there is a bar which is apparently 43D set up by the UAPA section 43D5. However, even if there is no bar, the only reason why bail should be granted if there is no prima facie case, if there is no active involvement. However, in the present matter, Your Lordship, there is a prima facie case being made out on all regarding all the 5 petitioners. The first 3 petitioners have made hate speeches and have planned, and that has been found out in the NIA investigation itself. And secondly, Your Lordship, for Vishy, she has published interviews of these influential people, which has further led to the communal violence in the peace ground. For Duffy as well, Your Lordship, even after having the superior responsibility of and being able to take down or remove the post, Duffy did not do so, and which is why all the 5 petitioners have a prima facie case against them, and which is why, Your Lordship, by virtue of section 43D5 of the UAPA, bail should not be granted, Your Lordships.
Thank you.
Your Lordships, it was an honor arguing before this honorable court.
Here is counsel number 2 from the end of the respondent. Counsel number 1 has already dealt with issue 1 and issue 2, wherein she contended that the present petition is not maintainable in this honorable court and that the petitioners 1 to 5 should not be granted with bail. May it please the court, the counsel would like to start with the submissions of issue 3 and 4, wherein she would contend that superior responsibility lies on Duffy, who is petitioner 5, and that imposition of UAPA charges on petitioner 1 to 5 is constitutional in nature. Does the counsel has the permission to proceed? Much obliged, Your Lordship. In furtherance to the contentions raised, the counsel would make a twofold submission on why Duffy, petitioner 5, should be held with superior responsibility. Firstly, Duffy intentionally disregarded the responsibility placed upon him by the central law and the Constitution of India. And secondly, right to life overrides freedom of expression. And not removing the post in the name of freedom of expression is a misnomer. Your Lordship, the respondent humbly contends that the doctrine of superior responsibility is a form of responsibility for omission to act and could apply in theory to any person who is able to exercise effective control over one or more people. In the present case, Duffy is the CEO of Twitter, was in a regulatory position. The review committee places subordinate to him. He failed to prevent or punish the crime committed by his subordinates in the nature of not removing the post or varied strata that led to countrywide violence and further damages. Your Lordship, as per the contention by the petitioner, Twitter as a platform exercises a great degree of control over its content. For that matter, every post goes through the system of Twitter and is reviewed by its review committee if further scrutiny is required. The posts spoken of were highly sensitive in nature and have had the potential to incite and add fuel to the communal violence. And in spite of such apparent grave nature of the post, Your Lordship, they were not removed. The counsel submits that in the era of the internet, sensitive posts on such a platform can cause havoc if such responsibility is not duly discharged. Arguendo, if these platforms generate income by using the information or the data available on their platform, then they have a responsibility of the same level of editorial as expected from traditional media too. The counsel humbly submits that the violence at the peace ground started before the post was made by Perk, and that his post going viral only added fuel to the communal violence that was already that already was caused. Therefore, even though
Counsel, just a minute. Are you arguing the issue on the question whether bail should be granted or not, or you are arguing the question whether there should be conviction or not?
Your Lordship, the counsel is arguing on the issue that Duffy should be levied with superior responsibility. In furtherance, the respondents are submitting that bail should not be.
Again, the question is superior responsibility or no superior responsibility. Are you arguing the issue on the question of whether he should be granted or should not be granted bail, or he should be convicted or he should not be convicted? What is the position that you are taking?
Your Lordship, the counsel is arguing that bail should not be granted to the petitioners.
What should not be granted?
Bail should not be granted to the petitioners.
So the only issue is limited to bail.
Your Lordship, the issue is also about the charges that have been levied upon the petitioners to be constitutional in nature, and that bail should not be granted to them.
In the context of bail, charges may be good, may not be well founded, but then in the context of grant or not to grant bail. That's all.
Indeed, Your Lordship, that bail should not be granted and the arrest is rightly made, is the submission of the counsel.
You are focusing only in respect of Duffy, not in respect of other accused persons. We have been saying that this is superior liabilities has been on the part of the Duffy. So he should not be granted bail. What happened in respect of the other accused? If there has been a chain of the circumstances against all the persons concerned, then
Indeed, Your Lordship.
What would you like to say in respect of other co-accused person who has been with the Duffy?
Your Lordship,
say that apart from the Duffy, other persons should be granted bail? You mean to say that you have been putting the liability upon that Duffy in much more escape than to the other persons?
indeed not, Your Lordship. The issues have been framed by the Honorable Supreme Court. And that is why the council is submitting that Duffy specifically possess superior responsibility and should be labeled with superior responsibility. In the meanwhile, the respondent is also arguing and is also submitting that all the petitioners should not be granted with bail for varied reasons.
Come to the point now.
Pardon, Your Lordship. Could you please repeat? If there are no further questions, the council.
Yeah, go ahead.
Yes.
Much obliged, Your Lordship. The council humbly submits that the violence of the peace ground started before the post was made by Perk, and that his post going viral only added fuel to communal violence, which was already been caused. Therefore, even though Duffy was aware of the impact of the speeches of petitioner 1, 2, and 3, the insightful posts were not removed. To refute the contention by petitioner 5 that they've been maintaining a balance with freedom of expression, the council reiterates that right to life overrides freedom of expression. Coming to the next submission, the council reiterates, Your Lordship, that not removing the post in the name of freedom of expression is a misnomer. Your Lordship, the restrictions under Article 19, Clause 2 of the Constitution of India override freedom of speech and expression under Article 19(1)(a). If there was an iota of doubt whether such posts can add fuel to the ongoing violence, the platform performing the responsibility diligently was supposed to take down that post. The petitioner, Your Lordship, is relying on the case of the petitioners in the present case, Your Lordship, is relying on the case of Vanish Bajaj for acquittal and safe harbor under Section 79. The council submits that just after this case, IT Act was amended and rules were introduced in 2011, which placed additional responsibilities on the intermediaries under Rule 4. And therefore, their contention is not valid. Thus, the council submits that placing the right of speech and expression over the life of the people cannot justify the omission that has been made by Duffy. Quoting Justice Kaul from the case of Ajit Mohan and others versus Legislative Assembly NCT of Delhi, case of 2020, the power and potentiality of these intermediaries are vast, running across borders. These companies cannot play hot and cold at the same time when it suits them. The council concludes a submission for issue 3 with the ratio of Ajit Mohan versus NCT Delhi, that with great power comes great responsibility. And Duffy, as CEO of Twitter, has not been able to comply with his responsibility to keep due diligence, but also conspired with petitioner 1.
Also, we have to balance the interests of free speech as well, right? If Mr. Duffy would have taken down these posts, then it's probable that somebody would have filed an objection and approached the courts again for violation of their fundamental right of free speech. To say that a platform which is performing free speech functions is interrupting their exercise of Article 19 rights. So a test has to be laid down, a balance has to be laid down. Now, this discretion when a platform should take down a post or not, in view of the petitioner, can be the test should be that where the petitioner platform receives a request from the court or from an investigating agency also, that would suffice the threshold of imposing a reasonable restriction of Article 19 right on the right to free speech. Now, in what the proposition you are canvassing is that even in the absence of any notification or request from any investigating agency or court, the platform should in its own discretion decide when to remove and when not to report. That, in our view, can also lead to a gross abuse as well. So therefore, where do you balance the rights? Why should Mr. Duffy reject and review each and every post that's put on his platform when there are millions of posts being put every day? Isn't it casting a very high and onerous responsibility on a platform?
Indeed, Your Lordship. The council submits that the violence in the present case was in front of Duffy, was in front of everybody, everybody for that matter. Even after the violence was in front, when everybody knows, every prudent person knows anything even of small nature, could incite violence, then a greater scrutiny was to be pursued. But then in the present case, Duffy did not do anything for that matter. Apart from that, Your Lordship,
there has to be a law for these things, right? We can't exercise these things on whims and fancies of each particular situation, because the fact situation you are telling us is very different from the fact situation that petitioners told us were prevailing in the country back in 2017. Have you made any law which requires an intermediary to exercise their own mind and remove a post upon the happening of ABCD situations? And if yes, then what is that law which they were required to follow and which they did not? Because if there is no law, then Mr. Duffy is not under any obligation to remove it. Simple as that.
Indeed, Your Lordship. The Council relies on the case of Ajit Mohan and others versus Legislative Assembly NCT of Delhi.
Is there a statutory provision?
Indeed, Your Lordship. In the IT rules, Rule 4 of 2011 IT rules guidelines, it is mentioned that the intermediaries can perform by themselves at certain instances if anything of this sort can be made out, if they have knowledge.
Is that what Rule 4 says, Council? Does it place a positive mandate upon a platform to remove offensive post? Have you read Rule 4?
Indeed, Your Lordship. The rule does not exactly place any responsibility upon any intermediary for that matter. But then, as a matter of fact, due diligence has to be kept as under.
So you're saying there's no legal obligation on them to remove a post, but more of a moral obligation to remove it. Is that your submission?
Indeed, Your Lordship. Also, the Council would submit that Rule 3 of the 2011 IT guideline rules. According to that, an intermediary has to keep due diligence while performing its duties. And therefore, due diligence has not been kept from the end of Duffy in the current case. If the Council has answered the question of Your Lordship, the Council would like to proceed with the next issue. Much obliged, Your Lordship. It is humbly submitted that levying charges of UAPA, Unlawful Activities Prevention Act, upon petitioner 1 to 5 is constitutional in nature. Considering the special nature of this act, the respondent humbly contends that acts of petitioners attract the charges as have been placed upon them. The Council places her submission in a threefold manner. Number 1, act of the petitioner were insightful. Number 2, petitioners have been charged rightfully. Number 3, no fundamental rights have been violated of the petitioners. In the instant case, Your Lordship, the petitioners Perk, Dora and Brownie resorted to insightful hate speech both at the peace ground during the event and on the social media platform Twitter without due regard to the sentiments of the public or taking reasonable care. Citing the case of Superintendent Central Prison versus Dr. Ram Manohar Lohia case, the anticipated danger should not be remote, conjectural, or far-fetched. It should have a proximate and direct nexus with the expression. The expression of thought should be intrinsically dangerous to the public interest. Your Lordship, in the present case, the speeches of Perk, Dora and Brownie did not just culminate in the chanting of speeches, but were insightful as they tended to trigger violence and were made with the same intention. Reliance can also be placed upon the findings of the NIA. If Your Lordship may refer to para 8 of the Moot proposition, that the roadmap of violence was drawn in a meeting between Perk, Dora and Brownie that took place at the residence of Perk. Article 19 Clause 2 of the Constitution, Your Lordship, guarantees freedom of speech and expression to all the citizens of India. But this article is subject to certain restrictions. The security of the state, friendly relations with foreign states, public order, decency, etc. Can't come under the ambit of reasonable restrictions. And therefore, speeches, including terminology like cockroach, treat how we treat cockroaches in our bedrooms, leech, give them what they gave us, clearly depict the malified intention of the petitioner to incite the people of the country. Your Lordship, the Unlawful Activities Prevention Act, clear from the name, is supposed to be a preventive legislation, that preventing and deterring incitement to terrorism in the interest of protecting national security and public order are legitimate grounds for limited freedom of expression. This requires the state to prohibit any advocacy of national, racial, or religious hatred that constitutes incitement to discrimination, hostility, or violence. The council submits that news broadcasting or publishing of interviews of Park, Dora, and Brown in the local newspaper by Miss Vishy amounts to instigation to the public. It is submitted, Your Lordship, that the interviews and the articles which have been published by Vishy have been found instrumental in spreading violence to the villages. To read it,
sorry to interrupt. How does publication of an interview amount to incitement and an offense under UAP? I mean, I'm sure you know that journalists globally have interviewed, leaders of LTTE and several other banned terrorist organizations, and these interviews have been published even when there was a lot of strife and resentment among the population. But those journalists were not accused of a terrorist act. Now, how do you justify the charge, justify the investigation under UAPA against Ms. Vishy? She does not belong to an unlawful organization. There's no notification declaring her organization as an unlawful, admittedly. So her investigation is only under Section 15 UAPA. Now, what subsection of Section 15 are you proposing to charge her under?
Your Lordship, arrest has been, council submits that the arrest of Ms. Vishy has been made because of her publishing certain articles and publishing the interviews of Park, Dora, and Brownie, which led to...
What is the source of your power to arrest a journalist for publishing an interview of even if I assume that she published the interview of a person who she should not have published, of an accused, where is the source of your power to charge a journalist for publishing the interview of an accused? You must have that positive power, right? We can't assume that power to arrest.
Your Lordship, indeed, Your Lordship, the council submits that at this point in time, the profession of an individual can certainly be overlooked when it comes to individual responsibility and diligence that has to be practiced. With respect to why Vishy has been charged under UAPA, it is contended that the articles have played a major role in and being instrumental in taking the violence to the villages. And therefore,
my question is under what provision of UAPA have we charged her under? All right, let's start with that.
Your Lordship, Section 18 of the UAPA.
Or terrorist activities, I'm guessing. Punishment for terrorist activities, right? That's Section 18?
Punishment for conspiracy, Your Lordship.
I see. Okay.
If the council will proceed.
Sorry. Yes, proceed.
Much obliged, Your Lordship. To reiterate the circumstances during the violence, if Your Lordship may refer to Para 6 of the Moot proposition, it resulted in over 100 deaths and loss of property worth $100 million countrywide. It is of utmost importance that justice is done, and every individual who played a crucial role in instigating the same is not supposed to be excused only on the basis of what profession they follow. Duffy, even after being well versed with the conditions of the state, was supposed to keep greater scrutiny on any and every material that would incite violence even more. He was sidelined under the blanket of balancing freedom of speech and expression for not maintaining diligence in his work, wherein what really was happening was him conspiring with other petitioners to propagate further riots. Vishy, on the other hand...
Counsel, you've not seen the essential ingredient of a conspiracy is meeting of minds. You've not produced any evidence or made any averment to the fact that the publisher of the interviews was actually conspiring actively with the other accused persons. Your averment seemed to be that she's interviewed them and merely published the interview, which by itself is not an act of bad faith. So how do you establish conspiracy?
Your Lordship, the council submits that petitioner 1 to 5 have acted and supported each other. 1 to 5 have acted and supported each other in the furtherance of violence. Petitioner 1 to 3, that is Park, Dora, and Brownie, drew the plan for violence at the residence of Park. The interviews were taken in furtherance of the same. After a few days of such interviews, hate speeches against the dungeon caste were made in furtherance of the plan. Duffy, the CEO of Twitter, clearly supported this agenda by allowing such hate speeches to be shared on his platform. And therefore, Your Lordship.
So from the facts you narrated, Miss Vishy has not given any hate speech herself. She has not participated in the conspiracy meeting that took place at the residence of Mr. Perk also. But still she's being involved in conspiracy because she published an interview. Is
Your
that by...
Lordship,
Yes.
Your Lordship, Vishy has been charged
That
because...
publication of an interview is subsequent to the event where people were killed or whatever it is. The publication of interview is not before the event, it is post-event. So, but she has narrated whatever she had heard.
Indeed, Your Lordship. Your Lordship, Vishy has been charged because her articles, the articles that have been published by her, were instrumental in taking the violence to the villages. Your Lordship, with reference to the factual matrix of the case, lakhs of people across the nation read newspapers daily. And when there is a clear possibility of people getting incited for communal violence because of the interviews given by influential people from a particular caste, such sensitive interviews should not have been published. However, Ms. Vishy did publish them.
But should not have been is where? I mean, this kind of norm or rule which you are talking of should not have been there. I mean, where is it prescribed? It should not have been. I mean, newspapers every day report dastardly things. They report gruesome murders. They report all kinds of things, events that occur. I mean, they even report on war. But does it mean that it should not be reported?
Indeed not, Your Lordship. But then there is diligence to be kept in mind. There is journalistic ethics that have to be kept in mind while reporting.
Punishment is not for ethics. Punishment is not for morality or lack of morality or lack of ethics. Punishment is for breach of the provision of law. So whether it fits into the breach of provision or not, that's the issue. And that is what my friend was saying, that I mean, any journalist reports about everything. Why should the journalist be punished for reporting?
Indeed, Your Lordship. Your Lordship, there is a clear violation of Article 19, Clause 2. That is, reasonable restrictions have not been kept in mind while reporting the articles and the interviews that have been published in the local newspaper. And therefore, in a way, the violence has been invited to take place.
Counsel, do you really believe that? I mean, what are reasonable restrictions? And the reasonable restrictions are over whom? Fundamental right is of a citizen. Reasonable restriction is a restriction on the state, on you, the prosecution. Reasonable restriction is not on the journalist. Journalist has a freedom. So in that context, you talk of your restriction. You can't talk of journalist restriction.
Your Lordship, the Constitution of India grants freedom, but with freedom comes responsibility, and therefore absolute freedom cannot be practiced, neither of anything. And therefore, reasonable restrictions have to be placed, have to be kept in mind while practicing freedom.
Where is that restriction? This is what my friend was asking. Where is that restriction that reporting should not be done of a gruesome event? Where is that restriction? No law prescribes such a restriction. That's what he's saying. You have to answer that. Reasonable restriction is not on the journalist. Reasonable restriction is on the state.
Your Lordship, reasonable restriction has to be followed by every individual that practices freedom.
Reasonable restrictions imposed by law, not morals. Please read, I would suggest, please read once again Article 19, 1 and 2 both.
Indeed, Your Lordship. Your Lordship, the Council submits that decency and general morality come under the ambit of reasonable restrictions which have been breached by Vishy while inciting by being instrumental in taking the violence to the villages. If that answers the question, Your Lordship.
Fine.
Much obliged, Your Lordship. On a concluding note, the Council submits that the objective of the Unlawful Activities Prevention Act 1964 rests in the prevention of activities unlawful in nature. And this plays a crucial role when it comes to safeguards placed by the state and stringent measures taken into consideration if and when found. In case of striking a balance between the rights of an individual to the rights of the citizens as a whole, the former becomes insignificant. Therefore, these stringent measures would not amount to infringement of the rights of these individuals. That concludes the submission, Your Lordship. If the Council is of no further assistance to the court, the Council seeks permission to proceed with the prayer.
Thank you.
Much obliged, Your Lordship. Wherefore, in the lights of the facts stated, arguments advanced, and authority cited, the respondent humbly prays before this honorable court, which may be graciously be pleased to pass an order that petitioners 1 to 5 are not granted bail, pass an order declaring the charges of UAPA pressed on Ms. Vishy as constitutional, declare that superior responsibility lies upon DAF. The honorable court may also be pleased to pass any other order which the court may deem fit in the light of justice, equity, and good conscience. All of which is respectfully submitted, counsels on behalf of the respondent. It was an honor to argue before this honorable bench.
Thank you.
So, with the permission of the honorable judges, shall we begin the rebuttal round?
Yes, we can do quick rebuttals.
Petitioner can begin.
Your Lordship, the contention that the council want to put forth for the respondent is that their whole of their arguments are based on this fact that because the NIA agency and High Court has rejected our bail for plea, so this honorable court need also to reject that same bail. But the council would like to state that what are the prima facie evidences you want to present in this court, because under section 141 the Supreme Court is binding upon all the courts, and under 136 it can act upon the judgments of other courts presented. So you need to present a prima facie evidences that are actually backed up with strong arguments. The council acknowledges that it is the matter of criminal conspiracy as alleged by the NIA. So we need to understand in this type of cases, the criminal liability is held backward, and for that we need to establish some circumstantial evidences. And for presenting circumstantial evidences, the council need to prove some chain of events, because honors of proof as per the section 106 of Indian Evidence Act is up to them. The council would like to ask the respondent is that you have arrested Ms. Vishy, and first of all, the council would like to clarify this court regarding the fact that the interview was published before the celebration. So this clearly shows that if that interview particularly would be that much enraging, then the violence would have taken place even before the celebration. So this clearly shows that that these are mere allegations that the published interview led to the violence. Also, I would like to ask, even if that interview was enraging, then why Ms. Vishy is held liable for? Because before publishing any interview, it goes through the chief editor of that newspaper, and the owner of why not the chief editor is being held liable? Why not the newspaper company as whole is being held liable in this particular matter? If that is the case, so although that is not the case here, the charge sheet is not filed since 5 years, and this is why the charge sheets have not been filed since 5 years, because even if you want to take if you want to contend that you are working on your investigation, but all we could see in this instant matter is that since 5 years you are only relying on the same evidences that you had back then, and no further progress has been made in the investigation. I would also like to contend that that the respondent had mentioned Mr. Ajit Mohan versus Delhi of Assembly case. So in that case too, it was held by the court that when there is a matter of liability of intermediaries, then CO cannot be held liable. It's the directors and board of directors who needs to be held liable for the same. So why the CO of the PITR is being held liable? Also, the council contends that since the CEO of the PITR is from Dungeon caste, the council would like to contend that on one hand they are saying that they should not be questioned because that the NIA investigation agents all belong to Dungeon caste, but then again they are accusing the CEO of PITR just on the basis he belongs to a Geon caste. Also, Your Lordship, they have contended that due diligence is not being paid, but due diligence was taken care of because the PITR has this automatic system of detecting the posts which are prohibited by their policies. So they did take the due diligence because the post was reviewed by the committee. Post was there was an automatic system in it, and when they were presented before the court, there was no such court order to actually take them down. These are the only contentions that council would like to put forth for the respondents.
Thank you.
Council seeks permission to begin with the three surrebuttals that the respondents have. Your Lordship, as has been contended by our learned friends on behalf of the petitioners, that there is no prima facie case and also the charge sheet has not been filed. Your Lordship, there is a prima facie case indeed for all the 5 petitioners. Your Lordship, there is a roadmap of the violence which has been drawn. And Your Lordship, the veracity of evidence is not to be checked at this stage of the matter wherein bail application has been filed. Your Lordship, the veracity of evidence is checked post charge sheet being filed. And also bail is not an absolute right, Your Lordships. Secondly, Your Lordships, it has been found in the NIA investigation that there is indeed a nexus between the activities which have been carried out by Vishy, the other 3, Perk, Dora and Brownie, and Duffy, which is to say that the roadmap which has been drawn at Perk's house, wherein Vishy's interviews created and incited violence because of which dungeon people attacked Geon caste people. And then these 3 people gave hate speeches in the peace ground, followed by Duffy not removing any controversial post, be it Mr. Perk's post, which incited violence, be it Dora or Brownie's videos, which called the people of dungeon caste as leeches and violence, all of which shows that there is a chain involved in furtherance of which the conspiracy did take place, and they're rightly charged under section 18 of the UAPA, Your Lordship. And lastly, Your Lordship, it has been found out in the NIA investigation itself that Duffy did take money from Mr. Perk. He was in Mr. Perk, which happens to be the first petition in the present matter. Duffy, being the CEO, took money from the petitioner 1, and also belonging to the same caste was inclined towards not removing the posts which could be insightful, which goes on to show that he had the malified intention also, being a part of this conspiracy to go against the integrity of the nation, Your Lordship. With that, the council finally submits her rebuttals. It was an honor arguing.
I hope that concludes. So what do we have to do now?
Judges, if you are having any remarks or comments, then you can share the same with the participants.
And how is
I had something to say on that. Recently, I found, the narrative which had been prepared for the purposes of advocating this discussion, perhaps, that seems to have been quite incorrect. And I think little more research should have gone into it. For instance, as we found difficulty in the issue of, the default bail aspect. The charge sheet is not served, and there is no point in arguing so much around and beating about the bush when the direct point is there. Secondly, most of you have ignored the fact that fundamental rights are that of citizens only. And state doesn't have a fundamental right. state can impose reasonable restrictions on the individual freedom. So the freedom has to be imposed by otherwise. So